This will be a facilitated session where I will be asking questions of the panellists. So I'll introduce our panellists, and I'll start with Erin Anderson. Next to Erin is Lucy Adams, which many of you will know. Next to Lucy is Mr. Eddie Haddad. And last but not least, Mr. Brendan Facey, and more broadly known in the public arena as the Sheriff of Victoria. So Eddie, what is going to be Fines Victoria?
Well, Fines Victoria essentially will replace the Infringements Court. Come the 31st of December, the Infringements Court itself will cease to exist, and Fines Victoria will replace the Infringements Court. And CCV, in fact, that's right.
And CCV.
And CCV. So your experiences with CCV will change. Fines Victoria will replace all those operations. Infringement registrars will no longer exist, given that the Infringements Court no longer exists. They will become review officers. I will no longer exist, or my position won't exist any longer. I will become the Assistant Director of Fines Victoria.
What will be the main changes in the reforms, and what are the timelines?
So the primary changes are around introducing better options for vulnerable and disadvantaged people with fines, and we've already touched on a few of them this morning, including the new Work and Development Permit Scheme, which is already operational, and payment arrangements is another positive feature that will help people to better manage and identify their fines. And that will be coupled with more effective sanctions for people who can pay but won't, which also we touched on this morning, the garnishee options, driver and vehicle sanctions, charge over land and whatnot, and bringing those forward in the life cycle to get people to pay attention to their fines much earlier. You also touched on shortened life cycle, which is again designed to encourage people to deal with their fines sooner rather than leaving them until they're much more heavily defaulted.
What is the role of the Director of Fines Victoria?
So the change, Eddie's touched on the change to Fines Victoria. So one of the things that we've tried to do in moving towards Fines Victoria and away from some of the other structures that we've got is first and foremost, and the Ombudsman talked this morning about specifically the move to an administrative system away from a court-based system. And a lot of the language in the legislation has been very deliberately simplified, and the processes cut in a way that's intended to make the system more approachable. So we also talked a little bit in Brendan's session this morning about trying to get contact with people earlier, and partly that's what that's all about. So we've simplified all of the notices in the past. We've put in a new website with a lot more self-service things in there, and so we're trying to deal with a range of different segments in the infringements system. So we're certainly trying to make it as easy as possible for people to pay and engage in that, in the significant numbers of people that do that in the infringement system in the first instance. But we're also trying to make it more approachable and easier, and more likely that people who might just be disorganised or put a bill down and not come and deal with that on time, to be able to do that, and so to increase that, because what we then hope is that we're then able to have more options for people who might be either vulnerable or disadvantaged or genuinely can't afford to pay, and also that will give us more time in order to be able to spend time with those things, because in that regard we have the same outcomes that we're looking for everyone as everyone in the room. So the Fines Victoria is also about that branding exercise, so that it makes it much more approachable for people, which is why we've removed the Infringements Court and Civic Compliance Victoria as names and entities in that system, so that there's a much more one-stop shop. And a lot of our things about that have then washed through into the way the legislation works around the payment arrangements, so that infringements, notices of final demand, whether something has a warrant issued, whether it's an infringement issued by any enforcement agency or a court, can be brought onto one place. We'll continue to do enforcement review, and we've talked a lot about that this morning. But the other part that we'll do, of course, and I'm sure Gary will have more questions on these, is also then running the administrative sanctions. And part of that is around, based on the same arrangement, about giving people notices that sanctions are about to apply in order to have them make contact with us and deal with the matter before the sanction has to be applied.
Maybe just continue on that, on the sanctions. Would be good to hear.
So if I direct people to page 19 of the practice resources that are there, there's, which, whilst unprepared by us, it's a really good diagram there that does two things. Firstly, the top half of each of those model diagrams shows you how the system works today and how the system works into the future. And as you can see, on the fines recovery model, right under days, in 77 days there, the right-hand purple box, administrative sanctions can be applied. And that's where the sanctions come in earlier. So many of those sanctions are currently the sheriff's sanctions, and a number and apply at the warrant stage in the existing system. A number of those sanctions come in then at the administrative stage, become the director's sanctions. So the best example of that you will have come across is when a sheriff's officer hands a person what's called a notice of intention to suspend either a car registration or a driver licence. That goes away from being a sheriff's sanction and can be served by post by the director on a person. Now, we have about... it does vary, of course, but a more than 90% response rate from people who are issued with a notice of intention to suspend. So that's the basis on which this type of sanction's been developed. And so we see 90+% of people then come forward and seek to deal with that. So, of course, a person in that situation who goes onto a payment plan, who puts in an application for enforcement review, at that point the sanction is not then applied to the person. And so that's the intention very much of the way those sanctions will work. Now, it is expected that that will be the sanction that we will use the most of, certainly into 2018. But as we've touched on this morning, there are a range of other sanctions, attachment of earnings and attachment of debts that we've talked about, garnishee orders, and it's not expected that we'll use those in massively enormous numbers, but we'll be working through with you with this as well, so that you have an expectation of what we're doing and how we're doing it and why we're doing it, so that the system comes along with this in the way that we understand it to be. We also have other powers about putting charges on real estate and with powers of eventual sale. So they're for significant powers that vest in the director, but there's also significant safeguards in the system that will enable people to stop those sanctions occurring to them by dealing with their infringements early. Now, the whole system, of course, is based on giving people prompts and warnings that something's about to happen in order to enable them to then approach the system and deal with that system.
Many people have had difficulty with is the term revocation, and it's been misunderstood. Can you tell us a little bit about that, and what will that mean for the existence of a special circumstances court?
So you touched on revocations along with the infringements court will be gone and instead replaced by the Director of Fines Victoria undertaking an enforcement review. One of the key changes is, along with the revocation, the concept of an objection will also go. Instead, it will be replaced by, for most people, it'll be a single opportunity to make an enforcement review application, with an exception for people who are applying under special circumstances grounds who may make a second application. So one of the key differences, I just touched on objections are going, is also this concept you touched on of opting in. So people familiar with the system at the moment know that even where an infringements registrar grants a revocation, the matter is referred to the Magistrates Court Special Circumstances list unless an enforcement agency opts out. And that's why we've turned that on the head and turned it into an opt-in process instead, whereby in the event of an enforcement cancellation, so where the director accepts the person's enforcement review application, the infringement notice will be withdrawn, and the option available to the enforcement agency at that point, they will have 90 days in which to opt in to a prosecution process at the magistrate's court. In terms of the special circumstances list, it is, at the end of the day, primarily a matter for the magistrate's court, how it organises all of its lists. I believe the magistrate's court has already been in contact with enforcement agencies and is intending to be in contact with people in this group as well about their intended listing practices going into next year. And it may well be once they get a feel for the matters that are now going to prosecution through this opt-in process, it may be open to them to take a different approach once they see how it's operating, the numbers in practice and whatnot.
An enforcement agency will have to issue a charge and summon, and some enforcement agencies will actually have to pay a filing fee with the court, and then actively prosecute those cases. So I think in due course we're likely to see enforcement agencies be a lot more considered about the matters going through to the magistrate's court.
How do you see the impact of the family violence provisions that are intended?
Essentially, we're really optimistic about the potential for these changes. From 1 July, we've already had family violence recognised as a special circumstance, so we can use that where there is the nexus between a person's experience of family violence and the offending. The really obvious deficiency in that is that it does involve accepting responsibility, and it applies where the victim did commit the offences. So we've got the gap, and what the family violence scheme is intended to do is capture both people who did commit the offences as a result of family violence and people where the perpetrator committed those offences. There'll be a specialist unit with trained people equipped to make those decisions based on applications that many of the people in the room will be making on behalf of clients. Very importantly, and this was a change kind of from the initial drafting that went in, there will not be a requirement to identify the perpetrator, and that's of course the single biggest barrier to using the existing nomination provisions, because there's a deep fear of retaliation and risk to safety as a result. So I think the biggest benefits are that we'll have an expert group of people making these decisions. There won't be a requirement to accept responsibility or a compulsion to identify the perpetrator. So certainly it looks like it will be a vastly improved system for our clients.
Lucy, can you tell us what you think will be the impact of the family violence provisions and how they will affect our clients, and what record will people get when they appear in court?
So in terms of the record that people currently get, people will know that if you go via the special circumstances list, you emerge with a finding of guilt, and the impact that can have for you in terms of your employment, and particularly people on particular visas, is significant. So the introduction of the family violence scheme, which avoids that, is a positive development for victims of family violence.
I'd like to ask you some questions. Somebody will come to a financial counsellor or a community solicitor, and they have special circumstances. Often they have a combination of all the special circumstances of mental illness, drug addiction, homelessness, family violence. And it's only the stabilisation of those circumstances that often enable them to come to our services to resolve it. And so what we see is clients with infringements at multiple stages. So there might be some where a 7-day notice has been served, and there might be some that are at warrant stage, and some that are at enforcement stage, some at infringement stage. How do we address this in our casework where we can no longer make a special circumstances or a payment application or a WDP for some of the fines that clients present with, but we can for the other fines they present with.
Well, I think that's probably the concern of everyone in the room, Gary, is that we're going to have people whose the 7-day period has expired for some or all of their infringements, and they will then languish in the system with no option other really than arrest and being brought before the court. And one of the things that we're really trying to avoid with the reforms, and as recommended by the Royal Commission into Family Violence as well, we want to reduce the number of these matters in the courts because the courts are overwhelmed, and I guess there is a real risk, even with kind of best intentions of people being prompted to act early, that a lot of people aren't going to. And I think we all know that the reason for that is because with the truncated timeframes, often the very circumstances that led to the offending will be ongoing and will compromise a person's ability to get help, to get advice, to take action. The sanctions that are administratively imposed, they're not just a warning sign or an indication to take action. They themselves are punitive and can be very damaging as well. So if we're talking about vehicle sanctions, licence sanctions, the flow-on of that is really that people aren't able to get to work or to get to services or to get the kids to school. So I think there's some of the concerns that your question opened up for me to speak about in a tangential fashion.
Look, I agree with everything Lucy has said. It's not an ideal situation in that respect. The legislation's fairly clear on the ability to lodge a enforcement review for special circumstances after the 7-day notice. What I would say though, and Brendan has mentioned this a number of times, that the regime as envisaged is likely to result in much early contact with individuals. Will engage people a lot earlier than would probably happen at the moment. And this is that warrants don't automatically issue. That the Director of Fines Victoria will take into account a range of factors when deciding whether or not to make application to the Magistrates Court for a warrant to be issued. I suspect that what is likely to happen in those circumstances is that if there is a special circumstances application on foot and matters that are not not part of that application because they are no longer, the individual is no longer to apply, those factors would be taken into consideration in terms of whether or not the director then sought a warrant from the Magistrates Court. The other thing to note also is that the director has powers to deregister fines, and I think they're, Erin, are they broad powers or are they focused specifically on certain situations?
The deregistration power, as you said, Eddie, there is an option for the director under certain circumstances to deregister a fine that's been registered for enforcement, and there is some discretion there. It'll also be used in the event that perhaps it's been identified that a fine has been registered in error and allowing us to bump that out of the system.
Or if the matter is better dealt with by the Magistrates Court, for example. So I was talking to a colleague earlier that, particularly with individuals who are incurring significant debt, the Director of Fines Victoria has the power to deregister those fines and send them through to the magistrates, or at least indicate to the enforcement agency that these matters are best dealt with through other avenues.
If we had clients whose fines didn't meet the criteria for a payment or WDP or special circumstances enforcement review, would we then be looking for the matter to be heard under a Section 165 in the Magistrates Court?
Well, it seems that under this option, if the 7 days has expired, that more people will be going down that path. One of the positive reforms is that 165 in its new form is vastly improved, and as Brendan spoke about, there are a number of safeguards that really mean that people should, prison really for unpaid fines is an absolute last resort in this system.
So if financial counsellors found clients with infringements that didn't meet those criteria and an open court hearing was required, then that would require a referral to a community legal service or VLA.
People should absolutely have legal representation for those hearings, and I think that's probably one of the other concerns is the pressure that will be placed on services with these shorter timeframes, because services are already under the pump, and if people are coming in crisis and with urgent timeframes, it's going to be difficult for services to keep up with that need, I think.
Okay. So, Brendan, 75% of a New Start allowance is 2/5 of bugger all. Very few people would have less than 75% of a New Start allowance. Under current legislation, Centrelink benefits are protected, but what we've seen in New South Wales is that there's been attachment of earnings for people on a Centrelink benefit. Can we get some kind of assurance that before anyone's bank account, any attachment of earnings or seizure of assets, that checking whether they're a Centrelink beneficiary would be done?
There's a couple of things about that, I suppose, in the first instance. Firstly, we're intending to roll out sanctions, so we're not looking to start day one and issue tens of thousands of them, of those types of natures. There are some complexities. First and foremost, we can't do garnishee directly from Centrelink. A Centrelink can only be an opt-in by the person approach. And we take about 60,000 payments a week through Centrepay now, so it's pretty well understood and pretty well organised in that regard. Secondly, we won't necessarily know whether a person is a recipient of a Centrelink benefit based on the information that we have when we've got the enforcement action before us. And that's the reason for which we'll send notices to people to say that this sanction will be done. So if we give a person 14 days, that's effectively 21 days, to say that a sanction will apply 21 days hence or 14 days hence. That person then can, of course, go onto a Centrepay arrangement, otherwise a payment plan, put in an enforcement review application, and then that stops the enforcement action in that regard. So there are a range of safeguards and a range of opportunities in that situation for people to take action and to contact us. There'll always be the contact details and information on notices and things that we give people. There will be all of that information on the website and the ability to self-serve with those things as well in our space. But in the end, you're right, some people will not take action and sanctions will apply. We're certainly not intending in the first instance to be rolling out tens of thousands of those sanctions until we work out how we can best tell, because we're certainly not. We've learned a lot from New South Wales and the applications of those sanctions in New South Wales. We're designing our systems to try and cater as best as we can for those.
One of the things that we've noticed from the New South Wales system is that where they have seized money from someone's bank account or something like that, and it's caused them undue hardship, that you can make an application for the funds to be, for that money to be refunded and a new arrangement put in place. So would that be an option available in Victoria?
It's a possible option, but we're looking much more down, certainly in 2018, of going down the garnishee from employers rather than looking to go straight through banks in large numbers for the very reason that you talk about. We're looking for the things that have the most effective response from a person when we say something is going to happen, where we, ideally we wouldn't do any garnishee orders, we wouldn't do any attachment of earnings. We would be in the situation where people come forward to us. So we'll work through that really carefully and seek to avoid it.
Eddie, in the last session, a lot of people were asking questions about payment arrangements. Can you tell us what fines will now be able to be included in one payment arrangement?
All fines, in fact. So any court orders, any fines at the infringement stage, and any fines that have been registered with the Director of Fines Victoria. That's the proposal. I think in terms of the groups of individuals that you deal with, the difficulty in wrapping all fines into a payment arrangement will be that we don't have direct knowledge of any matters that might be at infringement stage, unless they're tolling matters or Victoria Police matters. So, for example, Melbourne City Council, we have no visibility of fines at infringement stage. So there is an expectation that both the enforcement agency, Fines Victoria, the individual and their representative will work together to bring all those matters together under the one arrangement. But certainly for Victoria Police and tolling matters, they will automatically be included in the single payment arrangement.
Currently, there is a guideline that infringement court put out about payment orders, which said that if there was more than $10,000 outstanding, that someone couldn't have a payment order. And what many of us have found is that, and we understand the argument that if someone's paying $20 a fortnight to pay $10,000, it's going to take them years and they're likely to default. But for a lot of people, it's a better option than being an outlaw or going to court. The new WDP options are going to be helpful. But many of us know that it doesn't take many infringements to add up to $10,000 when all the costs are applied.
Gary, can I deal with the costs one first? Because I think that's one of the things that we're looking for the new system to deal with. As one of the reasons that we did change the rules a few years ago was to try and stop the thing that was happening where people were, significant numbers, were signing onto payment orders, could be with $2,000 or $3,000 and then defaulting out of them 4 and 5 and 6 times and ending up owing $15,000 and $16,000 by the time the warrants reissue and significant amounts of that. And in part, it was about preventing that from being the case. So given that was the rationale for it, one of the things that the new system then doesn't keep reissuing those fees. Things stay where they are in the system, and whilst new sanctions can apply while someone's not under a payment arrangement, that increase in costs, exponential increase in costs, won't happen into the new system. And so we'll take that opportunity, and we haven't finished doing that yet, to relook at what the rules are and the entry criteria into payment plans are, and particularly for people who are in that situation now, because our expectation is that over time far fewer people get into that situation in the infringement system because of the escalation of the fees being reduced. And as a result of that, we're looking at what we do in that $10,000 space and what we do around direct debit and what we do around self-service, as our new system lets us have a more holistic approach to how we do that.
Brendan, can you just outline some of what the new sheriff's powers will be?
The sheriff's powers remain reasonably consistent. So there's essentially, the sheriff will have continue to have the same responsibility, which is to enforce warrants issued by the court. So the powers of seizure and arrest remain the same. The notice of intention to suspend that the sheriff currently has as a power moves to the Director of Fines Victoria, and the Sheriff has that replaced with a power of removal of a number plate from a vehicle. There are also some changes around the execution of civil warrants for the Sheriff, which extends the time in which the Sheriff is entitled to do that, which fits more in akin to when we work, which means to 9 o'clock at night, rather than to kind of office hours, which will significantly improve the effectiveness, we hope, of the enforcement of civil warrants. And beyond that, that's really the change for the Sheriff. So the biggest change for the Sheriff and Sheriff's officers into 2018 will be the deployment of our new IT system, which will hopefully give us much better information and help out significantly with that, having all of the information in one place.
We touched on before internal review, the new internal review oversight and guidelines function. So like every other enforcement agency, Victoria Police must consider the guidelines when they're conducting their internal review processes, and I'm aware that they're very conscious of those guidelines and are becoming increasingly familiar with them. And also, Brendan also touched on before the removal of the default to court in the event of unsuccessful internal review special circumstances cases. Sounds like it's been welcomed in this forum, and we hope that that will encourage more internal review applications for people, again, as Brendan touched on earlier, people dealing with outstanding fines sooner rather than later would be beneficial. Regarding the opt-in process, like every other enforcement agency, VicPol will be subject to that 90-day opt-in. So there will be a decision-making process that will be undertaken by Victoria Police in the event of an enforcement cancellation. They'll need to consider, their prosecutorial guidelines and other demands on their resources and whatnot, as every other entity that's making a prosecution decision-making process will do, and determine within that 90 days if that particular matter, in light of an enforcement cancellation, ought to be pursued through a prosecution process.
It's not. The law provides that once that period is up, then those options are no longer available. But I think it's important to sort of cast back to the front end and to that enforcement stage rather than the warrant stage in that regard, because it's certainly the case that what's intended through the administrative sanctions and the shorter timeframes is to get people to deal with things earlier. So that range of things that starts back as simply as once a payment plan or a payment order today it defaults, then a warrant is reissued with new warrant issue fees. The new system stops things where they are, and then whilst they'll continue down the track if things default out and aren't being then dealt with, while they remain, the warrant issue fees don't reissue in the new world. And so those administrative sanctions that come in will be those levers that we have to get people to go to you and people that come to us, and so that we can then deal with fines, set up payment plans, take appropriate action. We have a very significant number of people that do that today. So the notice of intention to suspend that the sheriffs do wheel clamping activities, it has a 90% plus rate of having people come to contact us. One of the things that the whole system does is pushing people in that direction. Now, of course, if all of this works differently to how we expect, I'm sure the infringements working group will be having a conversation with us, and what we actually see in practice, we'll have that conversation and make recommendations to government if we see that. The real critical part of all of this is that the warrant, the issuing of the warrant, is no longer in the new system automatic. And so there'll be a decision by Fines Victoria about what warrants to apply to the court to issue. So it's an application on the director's behalf to the magistrate's court to issue the warrants. So we would expect a very significantly lower number of warrants to be issued into the future, and for an assessment to be able to be made in our systems about the utility of issuing a warrant and whether it's the most effective activity for a person and in respect of a person in the circumstances. So whilst I'm not seeking to downplay the concern, and it's clearly a real concern in the room and one that we'll watch carefully into 2018 right from the get-go, we're expecting that problem to be far less perhaps than an assumption that might be based on the way we issue warrants and 7-day notices today.